Thank you, Honorable Deputy Speaker, sir. The justice system in India continued to evolve through the reigns of the Mauryas, the Mughals, and the British. The present system has held India in good stead. However, this significant increase in the role of international trade, the economic development of nations over the last few decades has accompanied by a considerable increase in the number of commercial disputes as well. In India too, rapid globalization of the economy and the resulting increase in the competition has led to an increase in commercial disputes. At the same time, however, the rate of industrial growth, modernization, and improvement of socio-economic circumstances in many instances outpaced the rate of growth of dispute resolution mechanisms. In many parts of India, rapid development meant increased caseloads of already overburdened courts, further leading to notorious slow adjudication of commercial disputes. As a result, alternative dispute resolution mechanisms, including arbitration, have become more crucial for businesses operating in India, as well as those doing business with Indian firms. Sir, in sum, although a huge influx of overseas commercial transactions spurred by the growth of the Indian economy has resulted in a significant increase of commercial disputes, arbitration practice has lagged behind. The present arbitration system in India is still plagued with many loopholes and shortcomings, and the quality of arbitration has not adequately developed as a quick and cost-effective mechanism for resolution of commercial disputes. Accordingly, to the World Bank's Ease of Doing Business report for the year 2015, India is ranked 178 of the 189 nations in the world in contract enforcement. The World Bank's Ease of Doing Business rankings analyze the whole business ecosystem in the country. The rankings include parameters like starting a business, dealing with construction permits, getting electricity, access to credit, and enforcing contracts, among a total of 10 parameters. Sir, India has shown a significant jump of 9 places in the starting a business parameter and 29 places in getting electricity in the 2016 rankings as compared to 2015. However, there is a drop in the ranking by 6 places on access to credit, and the country's rank on enforcing contracts has remained unchanged at 178th position. The contract enforcement rankings factor in quality of judicial processes on the scale of 0 to 18. India's index of judicial processes is at 7.5. In the field of case management, India scores as low as 0.5 out of 6. With commercial disputes piling up and investors and businesses looking up to foreign jurisdictions and settling disputes, India is losing a valuable opportunity for growth. India is at a juncture where massive investment is needed to create infrastructure to spur economic growth and improve the living standards of the people. This is not possible solely through government investment. For instance, urban development and regeneration alone requires about $2 trillion USD up to 2030. It is imperative that we create an atmosphere where businesses are encouraged to invest in creation of public infrastructure. Until 1996, the law governing arbitration in India consisted mainly of 3 statutes: the 1937 Arbitration Protocol and Convention Act, the 1940 Indian Arbitration Act, and the 1961 Foreign Awards Recognition and Enforcement Act. The government enacted the Arbitration and Conciliation Act 1996 in an effort to modernize the outdated 1940 Act, sir. The 1996 Act is a comprehensive piece of legislation modeled on the lines of United Nations Commission on International Trade Law Model Law, Trade Laws Model Law. The primary purpose of the 1996 legislation was to encourage arbitration as the cost-effective and quick mechanism for the settlement of commercial disputes, sir. The 1996 Act covers both domestic arbitration and international commercial arbitration. The current ground realities indicate that these goals are yet to be achieved, sir. There is a growing recognition that arbitration is becoming a costly affair, which is a departure from the intent of 1996 Act. That is particularly true in ad hoc arbitration, where the fees of arbitrators are not regulated, but decided by the arbitral tribunal with the consent of parties, sir. Some of the arbitral tribunals consisting of high-profile arbitrators such as retired Supreme Court and High Court judges charge high arbitration fees. Further, it is an emerging trend amongst large corporations involved in the state commercial disputes, including government undertakings, to hold ad hoc arbitrations in five-star hotels and other costly venues. There is a culture of delays where proceedings are frequently adjourned. Arbitration is most cost-effective than litigation only if the number of arbitration proceedings is limited, sir. The prevalent procedure, 2 minutes, sir, before the arbitrators is as follows. At the first hearing, the claimant is directed to file his claim, settlement and documents and support thereof. The second hearing, the opposing parties are directed to file their replies and documents. At the third hearing, the claimant files his rejoinder. At each of these stages, there are usually at least 2 or 3 adjournments. The first occasion of considering the question of jurisdiction does not normally arise until the arbitral tribunal has issued at least 6 adjournments. If the respondent in the state is the state or public sector undertaking, the number of adjournment is higher and it takes more time for the parties in internally finalizing pleadings and documents that are to be filed before the arbitral tribunal. Parties pay fees of fee to the arbitrators for each hearing and thus spend substantial amount. This is in the additional to this, sir. The remedy this situation, the bill stipulates a period of 12 months for the arbitral. I will conclude, sir. According to a survey conducted by the Construction Industry Development Council, the amount of capital blocked in construction sector disputes is over rupees 540 million, sir. Given the trade piece of justice and recurring delays in the judicial system, it is essential that we reform the system to make it more cost-effective and less time-consuming. The bill moves the country in that direction and would definitely encourage investments and help India become a center of arbitration. This has been the government's sincere effort, and with this, I welcome the bill and support its passage, sir.
Thank you. Raja Mohan Reddy.